Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Rida Shaikh. She is going to speak on Overview of Indian Easement Act 1882. She is from KES Shri Jayanatilal H Patel College of Law. So without wasting further time, I would request her to commence with the lecture. Thank you.
Hello everyone, I am Rida Shaikh, a student of KES Shri Jayanatilal H Patel Law College, a 4th year BLLB student. I am honoured to give a presentation on an overview of Indian Easement Act 1882, a significant legislation that governs immovable property that ensures rights and also ensures rights and harmonious enjoyment of the property. In practical terms, the enjoyment of land does not primarily depend upon the ownership. It often relies on the property rights over the neighboring properties, such as right of way, passage, light, or air. The law of easement regulates these rights, ensuring that the property is used efficiently, fairly, and without any unnecessary conflicts. The Indian Easement Act 1882 provides a clear legal framework to balance the individual property rights with necessity. In this speech, I will be briefly explaining the meaning of easement, essential elements, classification, mode of accusation, and its extension. With this foundation, let us begin to understand what does an easement actually means according to the Act. The concept of easement is defined under Section 4 of the Indian Easement Act 1882, which defines an easement is a right which the owner or occupier of certain land possesses as such for the beneficial enjoyment of that land, to do or prevent something in or upon or in respect of certain other land not his own. This definition highlights that an element is not an ownership right but a limited right attached to land. The land for whose benefit the easement is created is a dominant heritage, while the land over the right is exercised is a servant heritage. The owner of the dominant heritage is a dominant owner, and the owner of the servant heritage is a servant owner. Thus, the essence of an easement lies in the relationship between two parcels of land. It does not transfer or ownership of the servant land, but merely permits a restricted use for the benefit of the dominant land. From the statutory definition under the Section 4, we can derive the following essential elements of the easement. There must be two distinct heritage, a dominant heritage and a servant heritage, owned or occupied by two different persons. The easement must be for the beneficial enjoyment of the dominant heritage. The right must be exercised upon or in respect of the servant heritage. The right must be permanent in nature, meaning it is attached to the land and not to the individual owner. These elements clearly distinguish an easement from the personal right or a temporary privilege. If any of these elements are absent, the right cannot be qualified as an easementary right. The classification of easement. The Indian Easement Act classifies into different categories to clarify the nature and mode of enjoyment. Firstly is continuous and discontinuous easement. Section 5. The continuous easement are those whose enjoyment is continuous without the intervention of human agency. Example including the right to receive light or air through a window. Discontinuous easement, on the other hand, requires human action for the enjoyment, such as right of way or right to draw water from another's well. Secondly is apparent or non-apparent easement. The apparent easement are those that are visible on inspection, such as a pathway, a drain, or a water channel. Non-apparent easement has no such visible signs, such as underground rights or a restriction on construction height. This classification helps the court determine the existence and nature of easement, especially in disputes involving implied grants. The Act also recognizes several lawful modes by which the easement may be acquired. The modes of accusation of easement. Firstly is easement by express grant. An easement may be created through a written document or deed where the servant owner expressively grant the right to the dominant owner. The easement, secondly, is easement by implied grant. Implied easement rise by operation of law rather than the express agreement. These include easement of necessity, section 13. This arises when a property is so situated that it cannot be used at all without an easement, such as access to a public road. Quasi-easement. These arises when a single owner uses one part of his property for the benefit of another and transfers that one part, any one of that part, to another person. The law implies the continuation of such rights. Easement by prescription, section 15. An easement may be acquired when it has been enjoyed peacefully, openly, and as of right for a continuous period of 20 years. This reflects the principle that long-standing usage should receive legal recognition. Lastly is easement by custom. Certain easement arises due to long-established local customs, particularly in rural, village, or the community-based settings. Easements are not absolute or perpetual in all circumstances. It can extend and be suspended. Under the Act, an easement may be extinguished by a permanent change in the dominant owner or the servant heritage, release by the dominant owner, unity of ownership where the person becomes the owner of both the heritage, expiry of time or completion of the purpose for which the easement was granted. In some cases, easement may be temporarily suspended, such as during reconstruction, and may revive once the condition laid down under the Act are fulfilled. I would like to also briefly address a few case laws that help to interpret the Indian Easement Act in 1882. Firstly is Manika Lal versus Fulchand, 1967. The principle established that the right of easement must be certain, continuous, and apparent. The court held if the right is visible, exercised, or lacks certainty, it cannot qualify as an easement by prescription. Secondly is Goja Brothers versus Ratan Lal, 1974. The principle laid that the defined concept of easement of necessity. The court held that the easement of necessity arises only when there is an absolute necessity, not mere conveyance. Thirdly is Ram Sarup versus Munshi, 1963. The principle laid the clarified easement can be claimed over government land only if there is explicit permission or long established usage. Through this, it has helped the court to interpret the Indian Easement Act in India. To conclude, the Indian Easement Act 1882 provide a well-balanced and comprehensive legal framework to regulate rights over immovable property. It ensures that the property can be used effectively and while preventing unreasonable interference with the ownership rights. By recognizing limited and lawful rights over another's land, the law of easement provides social harmony, legal certainty, and equitable use of property. It stands as a fine example of how law reconciles the individual rights with the collective conveyance. The law of easement, therefore, is not a merely technical legal concept, but a practical tool that governs every day-to-day interaction between the neighbors and the landowners. Thank you for your attention.
Rida, thank you very much. First of all, we are happy that you touched an act which is not talked more. People talk on transfer of property, contract, but easement act, it is a lesser talked law. So we are happy that you chose this topic and you had nicely given an analysis of this particular act. A small token from Hammurabi to you.